It is going to be a day of reviews here, but before I get to the other big review embargo that broke this morning, let me take note of this. Yes, the DOJ did indeed file an antitrust lawsuit challenging Visa's proposed $5.3 billion acquisition of Plaid yesterday, quoting TechCrunch. By acquiring Plaid, Visa would eliminate a nascent competitive threat that would likely result in substantial savings and more innovative online debit services for merchants and consumers, the DOJ wrote in its lawsuit. The deal would violate Section 2 of the Sherman Act, quote, and must be stopped, the DOJ wrote in its filing published by Bloomberg Law. In a statement, Visa said it, quote, strongly disagrees with the DOJ's, quote, legally flawed arguments. Quote, this action reflects a lack of understanding of Plaid's business and the highly competitive payments landscape in which Visa operates, the statement read. The combination of Visa and Plaid will deliver substantial benefits for consumers seeking access to a broader range of financial-related services, and Visa intends to defend the transaction vigorously, end quote. So here's why I think it's worth standing up and taking note of this. For years, tech companies have been able to make acquisitions of smaller but obviously disruptive players in their spaces in order to create the platforms that we know today, in order to create their seemingly insurmountable moats. Kneecapping is the term that I like to use. Taking out these competitors right before their disruptive growth could really see consummation. And somehow, for all these years, the government regulators didn't see the angle to what everyone was doing because it was, tech, too confusing for them. Now, I know that Visa is not a tech company, technically, but look at the language the DOJ is using there. Doesn't it seem like regulators suddenly know the score? That a DoubleClick acquisition, say, or an Instagram acquisition would be impossible to get muster for these days. All tech companies in the acquisition game should take note of this. This sort of signaling is possibly even more consequential for the tech ecosystem going forward than any antitrust suits actually brought retroactively.